Hi, you're welcome back to video 4A on law, and it's on adverse possession, squatters' rights as it's known as. Now, so that's it, 4A, and yeah, I have to be very careful giving legal advice. All right, for the law of contract is very general, but even on who owns what and all those things, an awful lot of law. I mean, you could spend 10 years studying something and you still wouldn't have it right. I often wonder, is there anyone really in Ireland knows it all? But there's a few things you can do to protect yourself, and I've seen some very sad cases and terrible distress over things that could have been easily prevented, and that's what I'm really here for. It's not to tell you all about law and then end up being sued. Now, I have to give a disclaimer. I can't take liability for this. Each case depends on its own. I can't claim how it will be used, and I could be wrong in some things as well. I can't put myself forward as a lawyer. I'm not a registered lawyer, and you're not my client, and you're not paying for it. So this is really to try to help a little bit to avoid pitfalls that nobody really wants, and nobody wants them. The courts or no one else wants to see, trying to iron out blunders after they're made. So essentially, adverse possession has a number of roots. It's rooted in old common law, and it's where somebody takes over land and uses it inconsistent with the wishes of the owner, and then takes it over adverse, or takes it over to the exclusion of the owner, and generally speaking, the world generally. Now, it's hard to give exact examples, but there was one case in England which is a bit inconsistent with Irish law, I have to say. And this crowd, it was Graham was the name of the case. This crowd had owned a field, a big company, owned a big field, a bit of land, somewhere in a great area. I think there was an airport near hand. It's worth millions anyway. So they bought it anyway, and the planning commission didn't work out. So they came along then and they let it to a farmer. And he walked away and he paid rent on for about 7 years. And he stopped paying the rent and they never came after him. And the time expired, the 12 years. And when they went to look for the land back, he said no, he had it. He acquired it by squatter's title. And he won that case. Now, it's hard to know would that apply in Ireland. There was a case in Ireland where Iron Irish Rail, somebody tried to take Clondalkin, land around Clondalkin railway station off them, and the fact that they had workers go in on it every year and fix up some things, even though there was a donkey on it or that, they lost. The Iron Road Éireann held the property. There was a case in Ireland too, and there's a lot of cases on this, and they're complex enough, that's why I won't go in on them. But there was a case too where a man came out to look at his farm every so often, and he stood on the edge of the road, and they said, well, no, you didn't go in on the land, but actually, if you own the land, you own the land to the centre of the road. That's the law. And so he was standing on his own land. So when he walked on the land along the road, he was on his own land, and he retained possession. Generally speaking, the Irish courts don't like it as much as the English courts. It's harder to take it off the owner, but there are certain circumstances where where it has to be done. And the Irish government objected to it being taken away as a law. Somebody took a case in Europe to the European Court of Human Rights, saying it wasn't fair, and the Irish government said no, we have to keep this law. Now, whether that's just to make money for lawyers or not, I don't know. But first thing to remember is there's no such thing as a house in land law. It's the land the house is on. That's it. If you have a house, it's the land it sits on. Doesn't matter whether it's a skyscraper or a cottage. It's the land it sits on that's actually registered and mapped. And the other thing I have here is the Statute of Limitations Act 1957 says that no action to recover land normally no action shall recover land after 12 years shall succeed. So if 12 years expires, you needn't be coming looking for your land if someone else is in adverse possession. Now, they have to prove that they have it exclusive to you and exclusive to the world at large as well, I think, and that they used it in a way inconsistent with your title. And one of the sad parts of it is that oftentimes people put kids up kicking football on a bit of ground or something, thinking that they're going to take it off them. But it has to be exclusive. They have to take exclusive possession of it. Just set the camera here, and they couldn't acquire title that way. Indeed, even grazing with a pony and that sort of stuff, you get these old fables about someone having a pony on a bit of council land or something like that, and or somebody else's land, and they acquire it. Well, if they use it and put cars on it and things like that and use it exclusively and don't let anyone else in and have it fenced off, well, you'd want to be going down there fixing a ditch or fixing something. You'd want to be doing something, and after a while you'd really want to have a word with the owner and say, look, it's my land, and you'd nearly want to be getting a bit of rent of them. So you want to watch that. But it's not easy taking land that's registered. And we're talking about here a land that you have already mapped, or where there's a mistake in the map. But you might at this stage be saying, well, I don't like that law, it's not very fair. But here's an example. And this happens regularly. I could tell you cases where it happened. So A here has a garage here, or a shed. And he's been using it for 60 years, and his father before him. Yet the map is drawn this way. The line on the map is drawn this way. Now, if you were to make the map absolute final, you'd have to have the mapper, the owner of this property, and the owner of that property present when the map is drawn. So in a lot of cases, the land registry people have drawn maps for houses, or architects draw up a housing estate, and they make mistakes, and that goes down on the map. And if you didn't have somewhere rectifying that with the position on the ground, you'd have terrible injustice, because you could end up with your sitting room would be on your neighbour's folio and his sitting room would be on someone else's folio. Do you know what I mean? Like, you could have it like that. So in this case, the owner of this demanded this back. This was on his folio, and it was on his map. He was the owner of it, and this fella here got a surprise when to hear this. So this had to go to court, because when he went to register with the land registry under the 1964 Act, you can register stuff if both agree. If both agree, you pay a fee, 180 euros or something, and you can re-register it in your name. But this fellow wouldn't agree, and that went to court, and then this person won. But it required a lot of money and a lot of expense on both behalf, you see, to get it sorted. So there's an example where the map cannot be taken as final. It wouldn't be fair. That line on that map is erroneous. It was drawn wrong by somebody drawing it that didn't have to take account of it. And you'll often get situations too. Long ago you often had villages where you had a doctor, a police station, and maybe a dental surgery and a dispensary, maybe 4 buildings in a row, and they're all belonging to the state. And then they're sold off, and they don't map them right at all. They just draw the map anywhere at all, draw the line and get it all wrong. So you have to have some way of reconciling the map with the position on the ground and the history of the situation. You understand now? So it's not as easy as you think. So then sometimes you get owners, let's say, overzealous. Maybe some old man has a caravan down the corner. I'll put him out of there because he'll only claim squatters' rights. Go down and get a bit of rent of him, or get him to sign a document to say that you're the owner and he acknowledges that. But you'd be better getting a bit of rent every year and give him a receipt and have a record of it and photograph the cheque or whatever. That cuts it, because if the person acknowledges the real owner, the paper owner, the map owner, at any time, and that he then is not in exclusive possession, he doesn't have the intent to dispossess the owner. So therefore, by paying rent, that saves an awful lot in that respect. Okay. And so he's acknowledging the paper owner, right? But possession can pass to sons and daughters in certain circumstances. So you need to watch that. But the main thing is some acknowledgement that it belongs to the map owner, the paper owner, or that. And very often you'll often get a situation where a neighbour sees that the map is wrong and they send a solicitor's letter to another neighbour, and the other neighbour goes bananas. This happened in one case, got all excited, and no, all the neighbour wanted was to put the map right. And in this particular case, the neighbour was getting old and was prepared to pay for all. And when we checked with them, I just want that map right. And when I checked the map, sure enough, it was out a metre. And this lady just wanted to put right. And when it was explained to the woman that was all upset, oh, my neighbour's suing me, she realised it was just a mistake. So that can be the happy ending to this. I like the map to be right. I love the map to be right, and I put lines on the ground, and not an inch out, not an inch. That's how good it is. But some people are very bad at reading maps, and some people make mistakes. So if you're now, what I'm really getting at here now, what I'm really coming to, because it's 9 minutes, is buying land or a house. The map versus the actuals. And fee simple is the best type of possession you can have. There's other types too, but I'll not go into them. Fee simple is the best title. Well, then you need to look at the folio you're buying and see that it's who's the full owner. Johnny Riley of so and so is full owner, and you're buying out of him. Lovely, he's selling it to you for a price, 200,000. And then you might see the ESB have the right to put a pole on it or a pylon. Well, they have authority under the Electricity Acts. That's all their rights are in there. That's okay. But if you see that the entrance into the house is belonged to someone else, the map may show not without the entrance. So the right of Michael Fitzsimons to the entrance. Now, if you own the entrance and he has a right of way in, that's one thing. If he owns the entrance, you may have a problem if you want to put up new gates or something. It's his land. You have only a right of way in and out. The other thing is, there's a lot of law recently about septic tanks and neighbours and all that, and I will not go into that at this stage. But make sure anyway that whatever, any facilities that's on it, if they're coming through someone else's land, that you have it under control. Because you could get a situation where a man might have a family and his daughter's getting married, and he might have his eye on this house, and he might bid 170,000. You come in and bid 180, and he bids 190, and he's hoping to get it, and you go on with 200,000, and he has a pick. He's not happy. You put him out of it. So he's not going to be too conducive to you. Oh, he'll be nice. He's been a nice neighbour. There's a history to all these things. So watch that. Now, if you're buying the land as well, you need to check the map with the actuals. Get a surveyor to do it. Someone that knows what he's talking about. Don't just rely on your solicitor, because if you want to do it on the cheap, your solicitor do it on the cheap. I don't know what the regulations are for solicitors, but you can't depend on them. If you want it done free, cheap, then they're not going to go out to read the map. If you're competent to read the map, then that's all right. I personally would be able to read it, but not everybody is. So if you see that the line on the map doesn't look right, there's something wrong. I had it over here before. Is this it here? Yeah. If you see this, hold on here a minute. Sure. This map says this belongs to him. That's no bother. Sure, that's all right. Sure, I'll be able to back you up on that. Sure, that's the way for years. Why didn't he fix it before he sold it? Does he expect to get 200,000 for this house when there's one up the road, the very same, with no problems, with proper maps? You need to either decide not to go for it till he fixes it, or bid him less. Bid him less. You shouldn't be paying the full whack for property, which you have to spend maybe 20 grand, 30,000 fixing. And you might never fix it. And you'll have bad neighbours, friends, and you're into an old mess straight away. So why did he not fix it? And don't forget, it could be because this is his cousin. Or he might be married to a woman whose sister's married to this fella. And if he annoys this fella, he'll get it at home, he'll be in the doghouse. So you need to watch that. And then we'll say you do buy it and you give the full price and you go to your man to put it on his map and he tells you no. He won't do it. You have to go to law. So you're talking about big money. And then when you sue this original fella, you bring him as a witness, let's say. You subpoena him. He doesn't want to go against him. He'll get sick. I have a sore toe, sore head. I can't remember right. Every reason will be put into he won't have the enthusiasm when he gets the money that he had before he got the money. So do not fall into that. If he can't fix it, you need to get it a lot cheaper. He can't fix it. You're better without it. If he can't put it right, then how do you expect to put it right? Maybe you came from Birmingham or Toulouse or Madrid or somewhere, and you're supposed to straighten these crowd out. Or maybe they're fighting each other back 400 years. You know, could be come back to the Tonbo cooling you. So you want to watch that. Don't expect to fix things afterwards, and don't be coming. It's awful to hear. Oh, I didn't know anything. Look at God's sake. You remember, there's the map. You're buying the property for a start. The house is irrelevant. You're buying the land. And there's a map of the land, or there isn't. If there isn't, you need that sorted. There's the actual situation on the ground. And the map and the actual situation should concur. And if there's a bit of it on the public road, then that's a bit harder. You need to see what the stories there is. But don't be buying land belonging to somebody else and having to win it then afterwards. That's my advice there on that. I hope I've made that reasonably clear. You can see now how it's not as simple. I bet at the beginning you said whoever's the registered owner should have the land. It's their land. But then what if the other family have had it for 60 years, and have no one has ever disputed it? You have to have some way to reconcile the map with the actual history. So that's it now. I think I have that dealt with there fairly good. So it's not that you have learned a lot from me. There's a whole lot of stuff about where people die and where there's inheritance and all owns the one and one's for all and all this sort of an awful lot of stuff in this. But that's fair enough. I mean, that's big stuff, and you'll be prepared to wait a while on that, and there'll be a few years passing anyway to get things sorted. But buying it is different. That's an Englishman's home or an Irishman's home is his castle. That's where you want to get in there and have a wee retreat from the world. And the last thing you want is a war with your neighbour. Come over here for peace of Ireland, and World War III breaks out, and the roaring and bawling and going on. You want to hear the Irish when there is, especially when they get a drop of poutine or whiskey or whatever. So that's it now. It's essentially that somebody can put you out if they own something exclusive. On the other hand, if the map is wrong, you can use that to your advantage. And get the bit of rent. If you're letting somebody use your property, get some bit of rent off them, and or some note. But a wee bit of rent is the simplest thing. A wee record of it, and that breaks it. That stops them claiming that they own it. Now, I don't know whether that was good or bad, but hopefully it's a wee bit of help anyway. And really, if you wanted to study law, that's what lawyers do, and they study it. That's where you really need a good lawyer and a good solicitor, and choosing that is another day's work. It's not easy. Not easy for lawyers to know everything anyway. But some of them specialise in land law and some specialise in other types of law. And you need to try and get somebody that's middling good at it. It's probably well worth spending the money. They have to feed their families too, don't forget. They have to feed their families too. So right, that's the story. Remember the main point. If you're buying, get it right. That's the main advice I have for you. And then you settle into your place and you have no more worries. It's not worth it. If they can't straighten it before they sell it to you, how are you going to come and straighten it? Particularly in Ireland, I don't think you'll have much success. You might win, you might get it all right, and you might go through all that, and hopefully you will. So I think I've done enough of muttering there, but I've seen a couple of cases. I've seen a couple of very, very serious cases. Poor people who had no money, and all this is going on, and they tell you then, we can't afford a solicitor, like we put everything into the house, and we've no money left. Oh, it's so sad. It's so sad. Don't part with the spondulics till you have your map and the actual situation on the ground in exact, what would the word be? Is it symmetry or concordance, or they're the same, whatever you like to use. Don't part with those readies at all. And do not let some fella sail off into the sunset and throw his problem over to you. Don't let that happen. Okay? Thank you very much.